Hi, so today I'm going to be talking about your release of liability assignment that you can find in Chapter 5. The first thing I always suggest that you do is look at all the assignment instructions and carefully read through all those instructions before you get started. This is the best way to be successful on all of your contract drafting assignments. Since this is your first contract drafting assignment in the class, I want to give you a little extra instruction about how to complete this assignment. So first, I would tell you to go into the Assignments tab of Blackboard and look for the Release of Liability Assignment. And when you open that up, you should be able to look at the introduction, which states that you're going to be uploading your completed assignment into that portal, and you're going to be drafting a contract called a release of liability involving a client, Mr. Mark Jones, who's a small business owner, and Mrs. Janet Cook, who is his customer. So you want to make sure that you read the facts in the situation details to help you draft the release. But before we get started with that, I want to discuss some formatting tips and some other helpful advice that you'll find necessary to be successful in completing this assignment. As you work, I want you to think about all of the rights that Janet Cook should waive. In particular, there's some questions in the assignment instructions that I would like to make sure that you answer and think about answering when you're drafting your release of liability. These questions include: what is the consideration? What protection does the client need in this release? Is Mr. Jones admitting any liability by paying Janet Cook? Think about protecting the client and all of the claims that Janet Cook can assert based on the above facts. What must be included in order to have a valid contract? You've been learning that so far by reading your textbook, listening to podcasts, working with other students in the class, doing the crossword puzzles at the end of the chapters. So I want you to think about what elements are required for a valid contract to make sure that you include those elements in this agreement. What sections or headings should be included in the release? And how will you organize this contract? That's what I'm going to really take some time in this video showing you today. So I'm going to lay out the organization and the heading of this agreement for you so you can think more clearly about what you need to include. Just to remind you that your release should be approximately 2 pages, double space, and to use Times New Roman 12-point font. Lots of times when we're including headings in a contract, the headings will actually have a little bit larger font than the text. And so if your text is going to have Times New Roman 12-point font, it would be fine to have your headings in a 14-point font. Sometimes I've seen headings even in a larger font than that. So let's talk about the purpose of this release of liability. And that is to get the client released from all known and unknown claims by Janet Cook. So in order to do that, we have to understand what her rights are before you start. Let's begin by thinking about what you will call this contract. And so the first thing I would ask you to do is come up with a caption for the contract. Might you call it a release of liability, a complete release of liability? It's up to you how to caption the contract. One thing I will tell you though, this is a formal document, so you should be sure to write in complete sentences and always check your grammar, punctuation, and spelling and do a final proofread before you submit your final assignment. The second part of the contract I would like to see as the parties. So you have to think about who who are the parties to this contract? So should Janet Cook just be releasing Mr. Mark Jones individually? Or you can see by the facts that he was doing business as Absolute Best Rug Cleaners in Wheaton. So should she also be releasing Mark Jones as doing business as Absolute Best Rug Cleaners? Okay, so you might, for the parties, have something like this. Mark Jones individually and DBA doing business as Absolute Best Rug Cleaners. Okay, so when you include the parties' information in the contract, you will also want to include their addresses. So after that, you can also fill in the address here. You will also want to have the other party to this release, which is the customer, Janet Cook. And of course, you would want to include her address as well. Now, I want you to think about how are you going to refer to the parties throughout this contract. Are you going to consistently refer to them by their names, Mr. Mark Jones and Ms. Janet Cook, or Mr. Jones and Ms. Cook, or are you going to give them some sort of title? So in other words, are you going to refer to Mark Jones as the business owner? Are you going to refer to Janet Cook as the customer? That would be an example of some labels that you could give to the contracting parties. Whatever you decide to do, the one thing I want you to be certain of is that you refer to the parties consistently throughout the entire document. I've had students draft contracts where at some point in the document they refer to the person as Mark Jones, another part of the document they refer to the person as Absolute Best Rug Cleaners, another part of the document they refer to this party as the business owner. As a reader, it gets very, very confusing when different labels are applied to the same party. And so I would just be very consistent and always describe the parties the same way throughout the entire document. Okay, so our third element that you'll want to include in this release of liability would be called recitals. And the recitals is really a statement that gives the reader background information. So, for example, how is a recital typically defined? It's a formal statement in a legal document that provides an explanation of the events leading up to this transaction. So what would you want to include then in your recitals section? Details about the dispute. So facts. In other words, facts. All right, so what facts are you going to include in this release of liability? Your assignment instructions lay out a lot of facts in the situation details. Do you think you need to include every single one of those facts in the recital section? And I will tell you, you don't normally need to include every single fact. But you need to make sure that there's enough facts in there that if a third party, like a judge, was going to be looking at this document in the future, that third party could ascertain what happened that led up to this contract, or what happened that led up to this dispute in this case, or this event. So I want you to look through the facts and determine what do you think are important facts, and what are the facts that you think the client, Mr. Mark Jones, would want included in this recitals section. Now, the next part of the release of liability will be the body of the agreement. So there's going to be several sections in the body of the agreement. And what I'm going to do now is I'm going to outline those sections for you, kind of like a checklist. You know I'm a big fan of checklists. You already know that based on my weekly task lists that I post in Blackboard. So I want to give you some sections that I want to make sure you don't miss and that you include into the body of the agreement, but you don't necessarily have to do that in the order that I'm going to present them to you now. So I will leave the order up to you, but just be sure that you have these sections in your release of liability. So let's start with consideration. So you know that every contract has to have consideration. It's a requirement of a valid contract. So this is going to be a bilateral contract. In a bilateral contract, we have a promise made for a promise. The consideration is basically some kind of legal consideration, legal promise that's made in exchange for another legal promise that's made. So what promises are these parties basically swapping? What are they making? What promises are they making to one another? Also, we want to make sure that the client is not admitting liability. Okay, so just because people settle their disputes does not mean that, in this case, the business owner owed the customer anything. Sometimes people settle their disputes because they don't want litigation to ensue. Okay, so we want to make sure that Mark Jones is not admitting any liability based on what happened. Also, you have to think about, who is Janet Cook releasing? Okay, so who is Janet Cook releasing, and for how long? So is she just releasing Mark Jones? Is she releasing Absolute Best Rug Cleaners? Is she, what if she dealt with an employee or two at the rug cleaners? Is she also releasing all of his employees? So I want you to think about who she's releasing and for how long. Then what is Janet Cook releasing them from? So what is Janet Cook releasing them from? Again, you've been watching a lot of videos. You've been learning about the liability that people have. You've been learning about damages. You've been learning about costs and expenses and things like that. So what is this release in regard to? Make sure that she's releasing them from something concerning the incident that you've described in the recitals section of your release of liability. Also, I want you to think about who the agreement is binding on. Okay, so again, could it be binding on the successors of the parties? Could it be binding on the heirs? For example, if Janet Cook dies, can her heirs now sue Mark Jones because her heirs did not were not bound by the terms of this release? Also, we want to think about the laws of the state that apply. Okay, so usually contracts have a term in them that describe what law is going to apply when or if there is a dispute over this contract. And so we want this, the laws of the state of Illinois to apply. Another clause that you're going to have is what's called a severability clause. You're going to learn more about severability clauses in a later chapter, but if there's a sentence or a clause or even a paragraph in a contract that's found to be unconstitutional or violating a statute, that could be a federal statute, a state statute, an ordinance, then that clause would be severed from the contract, and the contract would be enforced without it. In order to have that happen, we need to have language that requires that or allows for that in the agreement. And so that language is called the severability clause. Another section that you'll want to have in here is on capacity. So when thinking about capacity, you know that people have to be 18 or older in Illinois to have legal capacity to sign a valid agreement and have the mental capacity to understand the subject matter of that agreement. And then finally, you'll want to have one last checkpoint in your agreement, or one last paragraph that addresses merger. And let me write that on the list. Merger just basically means that this is the full and final agreement of the parties, that there aren't any other documents floating around out there that might impact their agreement, or any oral discussions that were had that were not part of this agreement. Okay, so that concludes the body of the agreement. The last section that you are going to include in your release would be the signature section. So remember that no valid contract, or I should say no contract, right, is valid without a signature section, because we must have offer and acceptance to have a valid contract. So the way that we see that there was an offer made and another party accepted it is through the parties' signatures. And usually we also have the dates of those signatures included next to the signature line. Sometimes we see a sentence prior to the signature section that says something like, this agreement has been voluntarily agreed to on this date. And then we would see the date included there. So you probably want to have some statement about it being, about the signatures being signed voluntarily, the dates that they were signed, and one signature line for each party. You would type the party's name underneath the signature line. Think about, would you want to have their signatures notarized for any reason? Not in all contracts do we see the parties' signatures notarized. Sometimes in a smaller agreement, it makes it harder for the parties if we require their signatures to be notarized, because they've got to find a notary and have the notary sign their, notarize, watch them sign the document. So just think about that. And since this is only 2 pages long, we don't have to worry about this, but in a long contract, maybe a 10 or 20-page contract, it would be very customary to see initial lines at the bottom of each page, and then each party would initial those lines to indicate that they've read and that they understand that particular page, and it's been made part of the contract. So even though their full signature appears at the end of the agreement, we see their signature on every single page. So that's something that we typically see in a longer agreement, certainly not necessary with this release of liability, but something I want to point out to you as well. Okay, so that outline should help you draft your 2-page release of liability assignment. Remember, it's only 2 pages long. Go back over the assignment instructions. Make sure that you followed all those instructions. Make sure you've proofread your document for grammar, punctuation, and spelling errors, and that you've included everything that we have on this list today. And then go ahead and upload your assignment into the assignment portal. Good luck on your assignment.